much-needed reforms to protect the American people from unlawful surveillance by their government while safeguarding our national security.
On the Fourth Amendment's not for sale, because that fits in with this fundamental warrant requirement that is just a hallmark of our system.
We wrote our Fourth Amendment to assure that such abuses could never threaten Americans.
Growing gap, because the court just decided in Carpenter that you need a probable cause determination and a warrant.
Firearms search and seizure. The Caniglia case was a unanimous decision addressing the warrantless search and seizure of arms within a home. The Torsivia case focuses on the community caretaking exception, a principle that allows law enforcement to hold a person indefinitely and potentially seize their arms permanently. Both rulings delve into your constitutional rights regarding firearm safety in your home and the circumstances under which law enforcement may enter without a warrant. One of the most intriguing cases, Torsivia versus Suffolk County, involves Wayne Torsivia, a 57-year-old man with no history of crime, mental illness, or homicidal behavior. On the morning of April 6, 2014, his teenage granddaughter contacted social services, alleging her grandfather was yelling and acting irrationally. Notably, she never mentioned arms during the call. Social services, in turn, contacted the Suffolk County Police Department. 3 officers were dispatched to Mr. Torsivia's home, and upon arrival, they concluded that the granddaughter's complaints appeared baseless. However, during a conversation between Mr. Torsivia and one of the officers, a minor incident escalated the situation. The officer accidentally knocked down a magnetic drape attached to the front door. When Mr. Torsivia bent down to pick it up, the officer loudly ordered him to back off, threatening to tase him. Mr. Torsivia responded by saying, "Please don't tase me, I could be destroyed. I have a heart condition." However, the officer claimed he misheard this, as Mr. Torsivia stating he wanted to be tased and wanted to end his life. Based on this alleged misunderstanding, Mr. Torsivia was arrested and placed on a psychiatric hold. Later, one of the officers ran a computer check and discovered that Mr. Torsivia had a New York State pistol license and arms at his residence. The officer informed his sergeant, who instructed him to ask Mrs. Torsivia to surrender the arms. The sergeant further directed the officer to threaten indefinite psychiatric hospitalization for Mr. Torsivia if she refused to comply. These cases are crucial in understanding the limits of police authority and your rights to keep arms secure in your home. Both rulings challenge the balance between public safety and individual freedoms, particularly when it comes to warrantless searches and the community caretaking exception. Broader legal implications. Eventually, the psychiatric evaluation of Mr. Torsivia came back clear 12 hours after his admission, and the mental health institution recommended his discharge. However, during the evaluation process, a social worker became aware that arms were present in his home. Acting on this information, the social worker contacted Mrs. Torsivia, pressuring her to surrender the firearms. Mrs. Torsivia was informed that her husband would not be released from the facility unless the arms were turned over to the police. Under the threat of an indefinite psychiatric hold, Mr. Torsivia ultimately agreed to allow the police department to confiscate his arms. Despite this compliance, it took Mr. Torsivia 2 years to have his rifles returned. His handguns, however, were never returned. The police used the incident to revoke his handgun license. This troubling chain of events, stemming from a baseless call by a teenage granddaughter, escalated into a situation where Mr. Torsivia was detained in a mental health facility and threatened with indefinite detention unless he relinquished his firearms. Mr. Torsivia's case eventually reached the Second Circuit Court of Appeals. The court ruled that the police's actions were permissible under the special needs exception to the warrant requirement. This decision largely disregarded a recent unanimous Supreme Court ruling in Caniglia v. Strom, which clarified the limits of the community caretaking exception. In the Caniglia case, the Supreme Court addressed whether the community caretaking exception under the Fourth Amendment applies beyond vehicles to include warrantless searches of homes. This legal principle originated from the 1973 case Cady v. Dombrowski, where the court ruled that police could search a vehicle's trunk without a warrant as part of their community caretaking duties.
Needed reforms to protect the American people from unlawful surveillance by their government while safeguarding our national security. Can you elaborate for us once more on how the FBI has abused its ability to conduct queries into U.S. persons?
The authority? Or do we want to actually put in place things that respect the checks and balances that we have in our system? On the Fourth Amendment's not for sale, because that fits in with this fundamental warrant requirement that is just a hallmark of our system.
The First Circuit Court of Appeals later extended this principle to homes in the Caniglia case, which led to a Supreme Court review. The Supreme Court unanimously ruled in favor of Mr. Caniglia, stating that warrantless searches under the community caretaking exception could not be extended to homes. Community caretaking. Justice Clarence Thomas, in the majority opinion for Caniglia v. Strom, emphasized the distinction between what is fair for vehicle searches and what is appropriate for residential searches. This principle was central to the subsequent Torsivia case, which followed Caniglia. In Torsivia, the petitioners sought the Supreme Court's intervention to overturn a Second Circuit ruling. The Second Circuit had refused to apply Caniglia, prompting questions about the scope of the community caretaking exception. The Supreme Court in Caniglia unanimously ruled that the warrantless entry into a home and the subsequent seizure of arms under the community caretaking exception were unconstitutional. However, the government argued that Caniglia was not relevant to the Torsivia case. While Caniglia addressed the community caretaking exception, the Torsivia case revolved around the special needs exception to the warrant requirement, which the Supreme Court has recognized in specific circumstances. The special needs exception applies to suspicionless searches serving distinct purposes beyond traditional law enforcement. Examples include Border Patrol searches, airport security screenings, jail inspections, and drug testings of students or staff.
For journalists or public officials, this is a matter of the Fourth Amendment right of every American. We wrote our Fourth Amendment to assure that such abuses could never threaten Americans, and that the evidence for that crime is likely to be found among my papers. Do I have that correct?
Technology and storing on the cloud, suddenly a large amount of your information has become vulnerable.
These searches aim to address public safety or administrative concerns, differing from conventional arrests and investigations. In Torsivia, the government argued that the community caretaking and special needs exceptions were fundamentally different. Therefore, they claimed that Caniglia's precedent could not apply. They further contended that the Supreme Court should deny review, asserting that the petitioner had not properly presented the issue of unlawful entry into the home. Ultimately, the Supreme Court sided with the government, agreeing that review in the Torsivia case was unwarranted. The court issued an order denying review, leaving open questions about whether this was due to a belief that Caniglia did not apply to the Torsivia case, or because of procedural shortcomings in the petition. The denial of review in Torsivia has significant implications. It allows states and law enforcement to point to the special needs exception as justification for warrantless home entries and firearm seizures. This creates a potential pathway for states with strict arm control laws, such as California and New York, to pursue more aggressive enforcement under red flag laws and other measures. These developments underscore the evolving landscape of legal protections for gun owners, highlighting the need for vigilance in monitoring how these exceptions are applied in practice. Impact of Caniglia and Torsivia cases. The Supreme Court's decision to deny review in the Torsivia case has significant implications for warrantless arms seizures. This denial allows states to rely on the special needs exception as a legal pathway to enter homes and seize arms without a warrant. In contrast, the Caniglia case highlighted the limits of the community caretaking exception, ruling that it could not justify warrantless entry into a home or arms seizure, as it had traditionally applied only to vehicles. Following the Supreme Court's unanimous ruling in Caniglia, the case ended with a settlement. Mr. Caniglia received approximately $31,000 in damages, along with attorney's fees. This decision emphasized the importance of protecting individuals from warrantless searches and seizures within their homes, reinforcing that such actions are generally unconstitutional unless a valid exception applies. However, the Torsivia case introduced a different dynamic. The government argued that the special needs exception, unlike the community caretaking exception, applies in scenarios unrelated to traditional law enforcement, such as airport screenings, jail inspections, or student drug testing.
As a union member, our union halls are the purest form of democracy. The opportunity to speak your mind should be free to go to school without worrying about being shot dead in their halls. Now, I want to say something about this, but I'm not going to stand by and let someone say that this is about the Second Amendment when our first responsibility is protection of our kids. We don't have to find ways to divide us, and we can have legitimate policy discussions. 69 days to do things that we know people who have laid their life on the line, like Chris Parsons, to protect this.
They contended that Caniglia's precedent was irrelevant to the Torsivia case because it dealt with distinct legal principles. The Supreme Court agreed, declining to review the case and leaving the lower court's ruling intact. This decision paves the way for states, particularly those with stringent arm control laws like California, New York, and Illinois, to expand the use of red flag laws and other measures. These states may increasingly rely on the special needs exception to justify warrantless searches and arm confiscations, raising concerns among arm owners about potential overreach.
Right, and what's particularly bizarre here is that the most famous case of the Supreme Court in the privacy area is Katz.
Allowed ourselves to get so far from these fundamental Fourth Amendment principles that underpin our liberty.
Growing gap, because the court just decided in Carpenter that you need a probable cause determination and a warrant.
With the shift in federal administration, broader Second Amendment policies are expected to emerge. This transition may further embolden states to aggressively pursue warrantless actions under the precedent set by Torsivia. Arm owners must remain vigilant, as these developments shape the legal boundaries of arm ownership and protection against unlawful search and seizure. The contrasting outcomes of Caniglia and Torsivia underscore critical issues surrounding the warrant requirement and exceptions to it. Understanding these cases is essential as they influence how far law enforcement and state entities can go in entering homes and seizing arms without a warrant. That's all for this video, folks. We'll see you next time.